sir.
That's why you were in jail. Because when you get angry, you start going like this. And that's not what we do.
I want the truth. You can't handle the truth.
Mr. Bueno,
Yes, sir.
how are you? How's jail?
Yeah, job been all right.
Do you know why you're here?
Yeah, for once.
Tell me again.
Once.
Come closer. Come to the bar. I can't hear you.
One.
Correct. For what though?
No, just
The assault.
assault. Yeah.
You know what happened with the assault as to why you got arrested?
I was in a mental health hospital.
And then what happened?
I had
Judge.
No, he's getting it. You're doing great, Mr. Bueno. You're doing fantastic.
Judge, this may go into.
Well, my point is that
I got hungry, and I asked the lady, I asked the guy for some food.
Judge, this is going into.
Okay, Mr. Bueno, your lawyer here, Mr. Laredo, wants to get you into the Harris Center to get you help. My fear is that if we do that, another assault will occur. And I do not want that to happen. The reason you are here is because no self-control. You must exercise self-control. Do you understand?
Sure.
That's why you were in jail. Because when you get angry, you start going like this. And that's not what we do. Do you understand? How do I know if we take you to the Harris Center that it's not going to happen again?
I wasn't on my medicine at the time. I guess taking my medicine will help me to stay self-control.
Are you taking it now? You're not taking your medication now?
Because I don't know which way to how to get my medicine.
Can we get him into medical or something so we can get him to the medicine that he needs?
Judge, my understanding is that based on what I have access to, he's on something. They're prescribing something, Risperdal, I think.
Let me see.
From what I'm able to check on, what I saw. So he's on something, to my understanding.
I'm supposed to be on 5 different medicines.
Judge, and this is one of those cases where I don't want to say too much, but
We're here as
schizophrenia pops up so much on his history, Judge. For years, it's been popping up. And so, the only reason I say that, I'm trying to get him some help, Judge.
Mr. Bueno, I want to get you into the Harris Center, but I want the people at the Harris Center protected. I don't want you to do anything like what happened at the other place. Do you understand?
Yes, sir.
I will give you one chance, but if you fail me again, you will be stuck with me in jail for a long time. I will only release him to the Harris Center. And we need to know that when you speak to the people at the Harris Center, that he knows that they know about the tendencies so that they are protected as well.
So, if I could just give you an update on why I'm proposing this, Judge. I did this in court maybe 3 weeks ago. The way this happened was, it was kind of the same situation where he needed help. I get in contact with somebody in the MAC. They tell me supposedly there's different programs or stuff. I explain to them what's needed. They make it happen with the Harris Center. We release him directly to the Harris Center, and then he gets his help. And then
I'm okay with it.
okay. And
but like I said, only if he gets released to them and they pick him up and they take him directly there.
Right, that's what we were able to do last time, and that'd be the expectation this time as well.
Okay, I'm okay with that.
Okay, so I'm gonna roll it to like, what's today, Wednesday?
So
Friday?
perhaps reach out to Brad Morris so that we can get into like a mental health PTI or perhaps something like that to that caliber, not necessarily a PTI or however they want to craft it. I don't care,
Got it.
but that they release them directly to the Harris Center.
Okay, I think I was kind of on board depending on what they say, but I'll keep working to that.
Judge, I think we should hold off on the PR bond until we have something set in stone.
Oh,
I'm not giving them a PR bond today, of course.
I thought that was,
No.
I thought that was the direction where we're going.
No,
No.
nope. Not until I know
Yeah,
where
sure.
we signed the document
Sure.
and we have a releasing document to the actual Harris Center.
Yeah.
That's only until that.
My only concerns were, once I can file the order, but basically the Harris Center will just say, we don't
No,
have a basis to hold.
we're not ready yet.
Yeah,
Not
so,
ready. It's too premature.
And that's where I'm
That's
getting,
the route.
yeah, that's where I'm getting in contact with Max, shredding everything up, so I have answers for you guys, and with the idea that he's
Yeah.
gonna be taken care of over there, and I'll come back with you guys, but everybody's on board, it seems like, so.
Yes.
Okay.
Mr. Bueno, self-control.
Yes, self-control. I'm trying to do that, self-control.
That's why everybody's in jail, because they have no self-control.
Start doing that self-control.
Good. Good things will happen then.
Yes, sir.
Okay.
Thank you, sir.
All right, Judge, thank you for the opportunity.
The Emperor is not as forgiving as I am.
State of Texas versus Adriana Harrison. Are you Miss Harrison?
Yes, ma'am.
All right, we were here previously and the court informed both parties that I would not be accepting the plea bargain agreement. It's the court's understanding that you all have reached a new agreement. Is that correct?
Yes, Your Honor.
We're going to proceed first. All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no
No
contest?
contest.
And the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Pursuant to our agreement, Your Honor, Ms. Harrison has a right to ask you to bend the plea agreement and give her, or rather reinstate her probation. And that support thereof in the PSI, it shows that they say she didn't have a mental health or didn't take mental health treatment that she attempted. But she did. I want to make that correct. In her hand are 2 completions of self-rehabilitative efforts in the jail of family violence. But she has a right to ask that outside of the agreement
Yes.
of 5 years. I asked the court to follow the agreement, but perhaps to consider taking both cases and putting her back on probation. Lastly, her mother's here in court and supports her. That's a good sign because of her past. She still has not thrown in the towel for her daughter. Do you want to talk to the judge?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Adriana Harrison.
All right.
I just want to say I apologize for my action. I just want to say I apologize for my action on my behalf with my daughter. I owe her a deep apology for acting the way I acted. And let's just say sorry to you for ending backing up in front of you, Judge, and for you to please give me another chance.
All right, what's your daughter's name?
Ariana.
Okay.
I don't. Nothing further, Your Honor.
You want to explain that to me?
I was trying to get my daughter back.
No, why do you have a knife in your hand?
Can you explain this?
And how old is your daughter?
She just turned 2.
All right, so do you realize that your daughter remembers you with a knife in your hand?
Yes, ma'am.
You need to work on your anger issues because this isn't the first time that you've been to this court for anger issues. And I know your mom would probably say, oh, she needs help with her mental health or she needs help with her drug issues. That's what I was giving you when you were on probation for that. And you didn't take advantage of it. You just doing whatever you want to do. So I don't know where your anger issues stem from, but you need to get those under control because otherwise, you know what's going to end up happening? You're going to end up being a habitual. You know what that means in Texas?
Yes, ma'am.
That means if you pick up another felony, depending on the type of felony, your minimum is 25 years in prison.
Yes, ma'am.
And then if you go to prison for 25 years, when you come out, your child will be an adult. Hopefully your child will not be before a judge with a defense attorney saying, oh, my mom pulled out a knife when I was 2 years old, and I was there to witness it, and she was being violent to her girlfriend, and she went to prison. So I didn't have anybody to raise me. That's what's called the cycle, and that's what ends up happening when you do these things.
As well.
All right, the court will follow your agreement, sentence you to 5 years in the prison. There's an affirmative finding of deadly weapon. There's going to be an affirmative finding of family violence. There's to be no contact with Diamond, Dylan, Angelus, and there's to be no unsupervised contact with minors. Are you the same Adriana Kisna Harrison, who was placed on deferred adjudication for the offense of continuous violence against family on November 5th, 2022 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 1, on or about the 6th day of September 2023 in Bexar County, Texas, the defendant, Adriana Kisna Harrison, committed the offense of aggravated assault with a deadly weapon in violation of condition number 1.
How do you plead to that? True or not true?
The state waives and abandons all remaining alleged violations.
Any objections?
No objection.
It's time that the defendant be sentenced to 5 years in TDC and that it run concurrent with her other aggravated assault with a deadly weapon, which you just sentenced.
All right, is that the agreement?
Yes, Your Honor, pursuant to the agreement, she's permitted to ask you to ignore it and put her back on probation, nothing further.
All right. Are you asking the court to follow that agreement?
Yes, ma'am.
All right, then the court will follow your agreement. The court will grant the motion, find you guilty, revoke, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact. There's to be no unsupervised contact with minors, and it's to run concurrent. All right, we can go off the record. You're going to have to do better. And obviously, you should not be in any relationship with anyone until you get your life together. And you should not be in a child's life until you get your life together, because children learn by what they see and what they hear. When you see a child who's using profanity and they're young, they didn't just like all of a sudden start using profanity. The people around them use profanity. And when you have a child who sees violence in their life, they start thinking that's the way you solve problems, by using violence. You understand?
Yes, ma'am.
All right, good luck to you.
I want the truth. You can't handle the truth.
What are we doing today?
Your Honor, we're asking for a preliminary examination on both cases, and I'd like to address my client's bond.
All right. Is all discovery complete?
Yes, sir, Your Honor.
Okay, yes, and ask about it.
Your Honor, currently as to both cases, my client does not have a bond. We're asking the court for a $30,000 cash assurity, 10% bond as to both cases. My client is not a flight risk. He does not have a passport, does not have a car, he does not drive. He is joined in the courtroom by friends, family, and family, which includes his mother and sister. We do not believe that he is a danger to the community at large. He has no prior criminal history that I'm aware of. We do acknowledge that the charges are serious. The court can address that through bond conditions. There are no minors or minor children that he needs to be around. He can go to his mother's home and not be around any minor children. He has numerous people that make to and from court. I've been in constant contact, mother, his sister, and family members who are all here to support them. They even brought letters in case I needed to do a more formal bond motion. So we'd ask the court to consider allowing him to do post a $30,000 cash surety bond as to both cases.
Response.
Sir, it's my understanding that bond has been denied.
Yes.
Yes, and Your Honor, I would request that the court consider that stance. Obviously, Judge, it's my best understanding, although I did not write the warrants in this case, that this pertains to sexual abuse of 2 are charged, 2 minors, but there are 4 that are involved. They're aged 4, 5, 6, and 7. They have all been interviewed. They all give various accounts of this defendant. So truly all various ones of those children.
Let me make sure I understand what you're saying.
I'm not saying.
There are 4 children that are involved,
Yes.
but as of this point, only 2 of the, whatever the incidents are regarding, only 2 of the children have been charged.
2 are charged victims. That's correct.
Got it.
There is information from their interviews that lead me to believe that after a preliminary exam, it feels likely that there would be additional charges involving the same children already listed and quite possibly the two other children. These children talk more readily about seeing the defendant assault one of their siblings rather than themselves.
I understand. Okay.
So Judge, I would not be surprised if there were additional charges following a preliminary exam. I would indicate to the court that something that has not been charged but was disclosed in one of the interviews involved a gun at the children and threatening them. Obviously, counsel's correct. He's facing significant prison time. These are 25-year mandates. And when and if additional charges are levied, if they also involve additional CSC first, those would be discretionary consecutive, as obviously we're talking significant exposure here. We're talking a year's worth of assault young children. I would ask the court to print a bond ruling, which is to be denied just for the safety of the judge.
Anything else, Scott?
Your Honor, there was extensive investigation here. No firearm was ever recovered from my client. The court will take the credibility of the children and inconsistent statements at the preliminary examination. However, again, all this can be addressed through no contact orders, house arrest, tether. He is not a flight risk. He is presumed to be innocent. And at this time, we do believe that the court has to find under that court rule that he is either a flight risk or through clear and convincing evidence, he's a danger to the community. I do not believe that there is clear and convincing evidence that he's a danger to the community with bond conditions that would include no contact orders with anyone the court may deem vulnerable at this point, Your Honor. So we'd ask the court to set the monetary bond with protectionary bond provisions, Your Honor.
The court does believe, and the court has reviewed the bond form that was filed by the people, that the court would consider the defendant to be a danger to the community as well, these children as well as any others. And while the court could certainly issue that condition, given the circumstances as the court understands them, that would not prohibit the defendant. I mean, it would be sort of an after fact that if we were to get there, and I don't think that that risk should be taken. I think that the magistrate followed the statute in regarding denying the bond. The court doesn't see a reason to change that. Motion for bond reduction is denied. Bond will continue as denied. Thank you.
Thank you, Your Honor.
Thank you for watching my episode till the end. I want to say thank you to my subscribers for helping my little channel get to here. If I could, I would kiss you all passionately, but instead, I'll feed this cat some more. If you like my selection and how I edit out the boring parts, please like and subscribe and become a subscriber of mine and some very fat cats. If you would like to check out a selection of my episodes, please click on and save the playlist on screen now to your YouTube. And I'll get to feeding this cat, who really is just very, very big boned.